Thank you for joining us for Hot Off the Presses, Recent Ethics Cases and Decisions. I'll be your moderator, Tim Anzenberger. I'm a partner at Adams & Reese in our Jackson, Mississippi office. And this webinar is part of a financial poise series on legal ethics best practices. If you turn to slides 6 through 10, it'll give you a summary of the series and this episode specifically. Now, speaking of the slides, we will not go through the slides in order, and you won't have to listen to us read slides to you. Instead, this webinar, like all Financial Poise webinars, is just a conversation among the panelists. And I'm looking forward to talking with the panel about ethics and technology and everything new that's happened in the past 6 months or so. As we know, as we see in the news every day, this is a scorching hot topic. So I look forward to hearing from our panelists on these items. You will want to keep the PowerPoint handy, though, because I'll indicate what slides our conversation is addressing as we proceed, just as a reference if you'd like to go through the materials. And joining me on today's panel are Steve Conover of Carmody, Torrance, Sendek, and Hennessy, Michael Downey of the Downey Law Group, and Julie Jorgensen of Spencer Fane. We know that you're attending this webinar to learn about ethics and not hear an infomercial about our backgrounds, so you can read more about us on slides 24 through 27. We'd also like to thank our co-producer, the National Law Review. Again, this webinar is a production of Financial Poise, and to sign up for our great free weekly newsletter, you can go to financialpoise.com/subscribe. And if you're attending the live premiere of this webinar, you can submit questions using the web portal that you're on. And if you're watching it on demand or have any questions after the webinar has ended, you can send those via email to info@financialpoise.com. Just include your question and the name of the webinar episode, and we'll do our best to get an answer to you as quickly as we can. And again, this is hot off the presses ethics best practices. And with that, let's get started. As lawyers, as we all know, our profession is built on a foundation of ethical rules and principles, and staying current with the latest developments in this area is not merely advisable, but it's essential and required by the rules themselves. And while the fundamental ethical rules and principles that govern our profession remain relatively constant, new cases and decisions continually require us to return to those foundational standards and examine their application in fresh and new context, shaped by new technologies, shifting client demands and expectations, and new guidance from courts and disciplinary authorities across the country. So today, we'll be focusing on recent cases, decisions, and trends that carry practical implications for your practice. So with that, Michael, let's start with you in just the basics, those basic principles. It seems there are new cases, new decisions coming every other week or month in the world of ethics and professionalism, but all these new cases seem to fall back on the same rules, same principles, same opinions. Can you educate us on what just some of those basic rules are that we see time and time again in new cases?
Sure. So there is a common core of cases and problems. Sometimes we say that basically everything that relates to lawyer discipline can be summarized very quickly on 4 C's. The C of client relationships is someone your client. The C of conflicts of interest, the C of confidentiality, and the C of candor. And then really that in some ways really does kind of capture most of the violations. We add to that actually the most common sources of complaints against lawyers, and these tend to be more smaller firm lawyers, would relate to communications and diligence. So I guess there's really 5 C's. We should include communication as the 5th one, but returning phone calls, moving matters forward, and then making sure you're conflict-free, that you're honest in your dealings with your court and other people, and then also that you protect confidential information.
All right, and I think one of the last principles you talked about, candor to the court, it has come up very recently. And so, Steve, I'll turn to you to kick us off with the first hot topic, kind of dovetailing off of that comment. And it's what everybody's talking about these days, and they have been for the past year or so, and that's AI. And these are slides 12 through 17 for the folks watching at home. It seems like there's a new case that comes out just about every other day with AI, or a new ethics decision or a new rule. So Steve, what is the latest right now that we're seeing in this area, whether it be cases or rules and best practices?
Well, you're quite right. The decisions that are being issued come out every day. It's not, it used to be every other day, but now it's every day. You can measure it based upon how fast the media is picking up on and reporting the decisions that are being issued, both by the courts as well as by the bar associations, keeping pace with technology by providing us with guidance of the guidance of ethics opinions. The primary focus has been hallucinations that are generated by the use of AI. And it's not just the hallucinations, it's the inability of the participants, whether it's a lawyer submitting a document to court that utilizes hallucinations, but it's the lawyer who's not reading or site checking and evaluating what the product the AI has created. The I, I can't really describe the most recent because I've already been an hour after I've logged off to monitor what cases have been issued. But the most noteworthy ones in the past 30 to 60 days involve instances in federal court where where the judges are utilizing Rule 11 to conduct show cause hearings when fake citations, fake quotes, and inaccurate or inappropriate representations of events or information are revealed in the documents submitted by the lawyers or the self-represented parties. Instances involve, as I said, not existent cases, inaccurate quotations lifted from existing cases, and misrepresentations. And as most of the cases involving, and they come from all over the country. It's not focused on any one part of the country or one group of lawyers or group of litigants. Cases involving IP, most of the litigation involves contested litigation, and it isn't limited to lawyer versus lawyer and party versus party. There are instances as recent as November and December of last year where lawyers have been imposed, sanctions have been imposed, including an official reprimand, financial fines imposed by the court. And for those of you who think for those lawyers who think they're insulated from those kinds of financial risks, fines are usually not covered by insurance. So to the extent there's a show cause hearing and a court issues a fine, it is typically going to be focused on the lawyer, and it typically is not going to be covered by malpractice, professional liability insurance. The most recent involved was last week, and it involved not only the issuance of a reprimand, but the requirement that a lawyer report him or herself to the state disciplinary authorities for their investigation and evaluation. That's on top of the reprimand that was issued in the court proceeding itself. There are instances where the party has been defaulted, instances involving self-represented parties who submit repeated hallucinations. And in one instance in federal court in New Jersey, the self-represented party didn't come clean at that show cause hearing, and the court entered a dramatic imposition of a default judgment. There are instances as well where the court may have been using or relying on AI without supervision or without checking. In that instance, particularly I believe it was in December, one of the lawyers who recognized that citations were inaccurate, that the lawyer wrote a letter to the court copying adverse counsel, alerting the court to some inconsistencies both in the facts as well as the case citations that were used. The court never acknowledged that they were relying on or using AI to prepare the orders that were the subject of the focus. But it is clear that it's not only the lawyers, it is the self-represented parties, and in some instances might even be the courts that relying on AI without site checking or double checking what they submit.
And that probably poses a new problem with the judges of the court using AI and inaccurate citations. We all know what to do if the opposing party has citations that don't exist in their briefs. You address it in the briefing. But what do the parties do when the judge's opinion comes out and it has citations that don't exist? That's, I guess, kind of another new world we're experiencing in 2026.
That's exactly right. In the instance I was describing in the federal court in New Jersey, the lawyer wrote a letter, not criticizing and not intending to be critical, but simply highlighting a level of inaccuracy that needed to be reviewed. It didn't seek any relief, short, sweet, concise, and diplomatic.
I mean, that does beg the question, though, is I believe in that case the order was simply withdrawn. They didn't reverse the order. They didn't. I don't think that anything has been issued yet, but you do certainly have judges that would not react as calmly, and the court hasn't really commented on the fact that it used hallucinated sites. Is that right, Stephen?
No, yes, correct. There's no insight. This is extrapolating from the level of inaccuracies that were issued in that order. And you're right, it was withdrawn. It wasn't reversed. It wasn't affected, and there hasn't been anything that I've seen so far so as to update that with adequate or corrected citations.
So, Julie, speaking of hot off the presses, there's a new case or a new decision that came out. It may have come out last week, but I think there may have been an updated order this week, and I've seen people posting about it. I've seen it in the news today, this morning, before we even started the webinar, and it has to do with the Southern District of New York's opinion in USA versus Hepner, and it touches on an issue at least I have not seen yet when it came to AI and legal ethics. Can you update us on that?
Sure. This was an order that came out in the context of somebody that was at the time a potential criminal defendant. There were indications he was under investigation, so he retained counsel, and he was having ongoing counseling sessions with his attorney. The attorney was giving him advice as to obviously what happens when the FBI comes to your door, if there's a search warrant, that kind of thing. So it was a fraud case. Eventually that happened, and they came in and they seized all of his electronic devices. Well, contained on the electronic devices were various prompts and documents generated from those prompts that embedded his attorney's advice. So it became an issue before the court. The Southern District, U.S. Attorney requested that prior to any initial disclosures that they go through and address this specific issue. And essentially they said, look, this is not attorney work product. This is client work product. And by the way, it was on Claude's OpenAI. So there was no expectation of privacy or confidentiality. The defense argued the documents were created for the purpose of the client communicating and gaining advice from counsel, so fell within the privilege of work product and attorney-client privilege. The court said no, at least to date, that I'm aware of. And one little thing with this is there was no claim that any of the documents were created at counsel's direction, which sort of begs the question, is that in and of itself, you could get your own client into an issue by asking them and not warning them to not use an OpenAI or certain types of AI products in order to assist you with preparing their case. And I think that we would be quite naive to think that that doesn't happen all the time. This is just one where, you know, a search warrant hit and it's very very to the forefront. Some issues, even with attorney prompts, are coming forward in the ESI context, ESI discovery, where prompts are frequently used in order to pull things together. And there is a case, Concord Music Group case out of the Northern District of California, which last year discussed some of that as, okay, if during the process and during your exchange of electronically stored information, some of the prompts are exchanged, does that mean the prompts that weren't exchanged are still work product? Or, you know, you get into the old sword and
Yeah.
shield issue, right? So those cases are evolving quickly, and I think imply something ethically on your duty to advise your client, as well as your ethical duty as you go forward in protecting work product and confidentiality.
Yeah, because I guess you never know what. I am sure there are clients all over the country that have been using AI to just draft emails to their counsel, to analyze their documents before they send things to their counsel, and the lawyers may not know what AI they're using, exactly which software they're using. So whether or not it's open and it's, you know, basically the AI is learning off of it, so it sort of deletes the privilege. So I guess that's going to be part of the engagement, I guess, going forward, is making sure your client knows, look, this is the AI that we use, and it's encrypted, it's protected. You, on the other hand, you don't destroy the privilege by using it yourself and using ChatGPT or Claude or anything like that. And I'm sure now, after this case has come out, we're going to be seeing more of it, because now everybody's discovery requests are going to have what AI are you using? You know, deliver all the history from it, and maybe subpoenas to ChatGPT and the like. So I'm sure there's going to be a lot more to come on that aspect. Michael, how about to you? What, with all these cases coming out, you know, daily, what rules and regulations are the courts actually putting in place, or legislatures actually putting in place to deal with it?
Sure. So the first thing, and Julie sort of suggested this, that we really are dealing with a Wild West situation here. Things are so new and developing very quickly. And as is typical, we start to see also some judges sort of make news by making decisions. Judge Brantley Starr in Texas adopted a local order that was noteworthy because he effectively forbade lawyers from using artificial intelligence. There's some other courts that have standing orders prohibiting the use of artificial intelligence. For example, one of the district courts in North Carolina. But I think, you know, what I would say about a lot of these is that they're not always very finely attuned to things as well. There's, you know, how are you using artificial intelligence? And a lot of times they don't really distinguish. So I think that's, you know, one thing we'll continue to see developments on. There also are state legislatures starting to take action. I know in California, there's been a Senate bill related to regulating the use of artificial intelligence. So again, it's very much up in the air. And one of the big things lawyers need to be aware of in this area is what's going on in their jurisdiction. Are there local rules, or are there, in fact, judge adopted rules or regulations that govern what they're allowed to do or what they need to certify in cases? And so really, you know, this is part of your practice. And if you're someone who practices all over the country, it becomes a lot more challenging keeping up to date on everything.
Julie, let's talk about when there is a violation and the court's going to enter sanctions. They usually enter the show cause, as Steve discussed. But what considerations are the courts thinking about and using, and what's their guidance when they're actually issuing sanctions? I know there have been some cases where the firm itself has to appear and describe, you know, what procedures it has in place. But what are these considerations? What happens at that stage?
Well, and these cases are interesting in that a lot of them roll back to what Michael was talking about as the core of a lot of attorney ethics and malpractice cases. And many of them involve local counsel. And I think for a lot of people, being local counsel is quite lucrative. You look at it for conformance of the rules. Does it look right? Uh, are the appropriate rules cited? Do the case sites look correct? But until recently, the duty was not to drill down into the actual brief itself. The content of the brief is the brief correctly citing? Do the cases exist? Is the argument legitimate? So you're basically now a second level reviewer. And the thing with these sanctions that are coming down, a lot of them are for federal courts, a lot of them include local counsel, and a lot of them involve very large firms. So I think there's also an expectation that if you have a large firm that comes in and your local counsel, they would have their own checks and balances. And the courts have said that's not good enough. When you say that you will be local counsel and they can pro hoc in on your membership, you're undertaking a responsibility to the court, and they're also sanctioning local counsel. A decision, Lifetime Well LLC v. IBS Spot, fairly recent one, January of 26. It also told you what not to do. So the approaches taken in that case. So local counsel kind of fell on his sword and said, you know what, I should have done this. I've gotten complacent and did what, DUI lawyers often advise their clients to do. Go out, get education, take courses, get certified, implement policies, look at your existing policies and procedures, and do they need to be revised? He did all that and responded to the court that he had done all that. Lead counsel took another tact, and the court didn't sanction her firm. And the entire firm was involved in the production of this document, sanctioned her personally, and said no funds of any sort, nor may you be reimbursed by your firm for this sanction. She really, through a newly hired, they called the person the unnamed law clerk or something like that, but they were a recent grad. And what makes this case interesting, and with all the marketing that are being pushed at attorneys, is, oh, those open source, they're crap. You need to watch for them. But our proprietary systems are different. Okay, proprietary systems also hallucinate, which nobody talks about that much in their marketing, but is absolutely true. And guess what they used in this January case? It was Lexis Plus AI and Lexis Protege. So they were on a proprietary system. And there were 8 identified hallucinations in this case. Lead counsel didn't really take responsibility for it, although it was found out that 2 other additional cases, the same individual drafted motions and briefs in, and they simply fired the new grad and took very little responsibility for it, other than saying, the time pressure. Time pressure comes up in all these cases, and as well as personal duties. And the lack of taking ownership as supervising counsel is a huge issue in this case. And the court absolutely drilled the lead counsel on it. And so not only personal monetary fines, they were required to send, actually both local counsel did not get any monetary fines of any sort. There was monetary fine for lead counsel. Then both of them had to send a letter to an organization, and it was all legal organizations that were designated, including the memorandum in order in the case, the firm's updated AI policies, and the court-specific request to distribute it to that organization as well as all the members. Like, I screwed up and the court wants me to tell everybody about it, plus learn from my mistakes. Lead counsel also got hit because it was known that this clerk worked on other cases. She was required to distribute essentially the same thing to all the other courts where similar briefs had been submitted. So it's just simply an ongoing issue, and it highlights the need for you to be very proactive with your AI policies. And I mean, I feel like, Tim, you're the only young one here. I'm going to sound like the old crotchety person, but perhaps Michael and Stephen agree with me, is it seems like there's two ends of people that get hit with these AI hallucination cases. It is the brand new attorneys that they've used it throughout school, they've used it throughout law school, and it's a reflex for them. And then older attorneys that are, for whatever reason, pressed for time. There's a case out of Kansas where, somebody had a spouse with health issues and they just want to get something turned in. Neither are completely excusable, but keep in mind the courts don't like you to fire the person and not have a learning experience and update your AI policies. AI policies definitely should address what type of AI you can use, because we were talking about AI, open source versus others. You should, and the idea that any AI needs to be approved by the firm. And there has to be a policy that really talks about, back to Michael C's, maintaining confidential firm and client information and what that means and where you can put it. And it's not just in research. There's a lot of AI that's being used in ESI discovery. There's a lot of AI being used in a variety of variety of different applications. So, be careful with your policies to cast a wide net, I guess I would say. And then the other thing that I think, confidentiality, competence, diligence all comes into this, but there are new issues arising with also the potential for stepping on it in copyright and trademark as well. So,
Steve, I think we've seen a lot of the cases with the lawyers and the law firms, but you mentioned pro se parties using AI and the problems that that's having. And my mind goes to the sovereign citizens. I think everybody may have had a time or two where they've had to deal with one of those plaintiffs. Before AI came around, they could generate a significant amount of paperwork that the court would have to read and you would have to respond to, and the clerk's office would have to manage. I can only imagine it's worse now with AI. So how can lawyers deal with this? How do we call the court's attention to it? How do we do it respectfully? How do we deal with this, which can be an expensive endeavor for clients?
The measured response is going to be a difficult balance. The advocacy that lawyers need to undertake, because that's their obligation to their clients. The candor to the tribunal, that's another duty that the lawyers owe, and that's to whether it's the court or the administrative judge. But at the same time, they have to restrain themselves from a level of criticism that looks poorly on or sounds nasty. The Colorado, most recently in late January of this year, the Colorado Supreme Court addressed an appeal taken by a self-represented plaintiff the appeal was from a summary judgment that was granted in favor of a defendant represented by counsel, capable counsel at the time. But in the Colorado Court of Appeals reversed the trial court's entry of judgment, summary judgment, remanded it to the trial court. And that would have been fine, but they decided in two additional pages after they remanded the case, decided to create what they thought was obvious guardrails as it related to the lawyers representing the defendant. And I'll quote just a few comments because they are real gems. The court described the tone and tenor of the response to the appeal. They describe vigorous and thoughtful disagreement about the law, and the facts are expected. Zealous and spirited advocacy is expected. Personal and gratuitous attacks on self-represented parties, like those advanced by defense counsel, are not. Nastiness in legal briefs isn't persuasive, effective, or helpful. The court described it as quite the opposite. They strongly suggested that counsel reacquaint themselves with the rules of professional conduct and the oath they took when they were admitted to the bar to encounter people and treat them with fairness, courtesy, respect, and honesty, close quote. The level of criticism that the lawyers introduced into their brief was only met by the court's criticism of their tone and tenor. There's a delicate balance. Advocacy is one thing, criticism that, while maybe warranted, and the level of frustration is clear by reading the 36 of the 14 other pages of this decision, the defense counsel's frustration was elevated with what they thought was a frivolous appeal that the Court of Appeals disagreed with because they did reverse the trial court and remand it. But that wasn't simply a misguided idea. It was misguided to bring in the personal attacks. And you have to restrain oneself when pointing out false citations, inaccuracies, and the idea that the self-represented party is using every resource they can with holding on by their fingertips to keep themselves afloat and keep their case going. It is a delicate balance, and restraint is apparently warranted in most situations.
I think it was Brian Garner that said, "Always right with a smile." So that can be hard to do sometimes, but I guess it's very important to keep in mind even when dealing with pro se parties. Particularly now that sometimes you get 1,000 requests for admission that are generated by AI, and it can be. But I just want to comment. I think at least the bar associations I belong to have all had civility presentations lately, and so I don't think that kind of ire is just aimed necessarily at pro se people. And I think the judiciary and the councils for discipline have about had it, is my impression. I don't know how you guys feel about that.
The repeated use of it, which also applies to the AI flaws that lawyers are encountering. How did it happen, and why isn't it going to happen again? So to the extent there's incivility or lack of courtesy, lack of criticism leveled among and between lawyers, that's never going to achieve its goal. There's a coach who had a lot of witticisms, and he said, "You're never going to get ahead by trying to get even." And the attitude that one has that wants to get even, to respond in kind, is not going to benefit the client, and certainly creates risk of focusing the lawyer who's making that additive and responsive accusation, just as large a target on his or her back as the initiator of the nastiness or the incivility.
Well, and the tough thing to be mindful of is that courts in particular are able to deal with incivility in a lot of different ways. And one of the things that I often have to tell my clients is, if we're patient and we act as the good guy and they're acting as the bad guy, the orders, the judgments may go in our favor. And sometimes you just need to hope that your client's willing to wait that long, because it is hard, to take the hits and take the hits and take the hits. And it took me a while to really figure this out, but the polite way to draw attention to things. I actually did a response to a motion to compel one time where it was titled like the 15th motion to compel. And of course they're thinking, oh my God, my client must be awful. And the first section went through the prior 14 motions to compel and laid out what had happened with each of those. Most of them were like, we'd ask for additional time. They'd file a motion to compel and then withdraw it because they'd given us additional time. We're like, why are they even wasting their time? Well, I think the court very quickly realized, and just a very objective statement of, here's the previous motions and here's what happened to them, told the court like, no, we're not being a problem here. They're just trying to set us up and being jerks about things. And so you really want to think about that objective, how can I be polite and tell the judge what's really going on without, using the names and things. I tell people it's often best to state the facts without using adjectives and adverbs. So.
And to Julie's point, it's very difficult for out-of-state counsel who have hired local counsel for the local counsel to say, take out the adjectives.
Yeah.
The righteous indignation doesn't carry with this particular judge or in our court system or in the district court that we're sitting. But nonetheless, they take out half the adjectives and adverbs and leave the rest that still make it sound as if a level of antagonism is necessary in order to accomplish the goal. It just doesn't work.
That's probably particularly hard when the local counsel is friendly with the lawyers on the other side and has a good relationship with the judge and the court staff, and then they're asked to file something that is something that would never come out of their mouth, and I guess that's another element of it as well. Staying in the technology world, but moving away from AI, let's talk about social media use, because there have been some recent cases. Social media has been around for a long time now. I mean, since 2004, 2006 when Facebook came out, but we're still seeing issues with it recently. Julie, what have you seen recently with social media that we need to be aware of?
Well, and this again kind of goes back to somewhat local practice. And I'm going to emphasize, from an ethical perspective, you always have a duty to look at local rules. And God help us, some district court judges, sorry if anybody is, have so many standing orders that you need to go through. And it also, this case has to do with the duty to supervise. So there was a case in California where a jury consultant was hired. And the jury consultant did what a jury consultant does, which is investigate, or at least in part, investigate your jurors. And the jury consultant, also searched LinkedIn. This particular judge prohibited the searching of LinkedIn. That certainly is not uniform throughout courts, but it also points to the need, again, to look at local rules and a particular judge's standing order. In the case, which is Contour IP Holding v. GoPro, the judge actually says that the sanction amount was much less than he initially intended because of all of the things that the counsel who uncovered the violation did. So this was Alston Bird ended up with a $10,000 fine for essentially a direct violation of the standing order that you cannot research jurors on LinkedIn. The idea is jurors will know that you're searching them regardless of whether you do it anonymously, because you still get alerted to anonymous searches. So, you're selected for a jury pool and suddenly, 20 people were researching you and it jumps up to 85. I wonder what's going on. And so he saw that as alerting the jurors and to a degree, direct juror contact. He also was very adamant that, and it's very clear in his order, he feels like there's been a severe invasion of privacy through various sorts of social media. So he was very adamant about that. LinkedIn was his particular issue. But even though the jury consultant did it, and this goes back again to the local counsel argument, Alston and Bird still had an obligation itself to comply with the standing order. And the order says its failure to adequately inform and supervise its consultants, intentional or not, warrants a sanction. So again, this is your duty to supervise, to inform, much like the lead counsel in the other case that got hit because there wasn't adequate supervision and review of a brand new attorney's work. Alston and Bird, although this fine is substantial, it was more modest than originally contemplated because, they bent over backwards. They immediately informed the court. They informed opposing counsel. They gave opposing counsel their research. And so, but for that, I think that the result may have even been a mistrial in this case. So it very much be proactive. And I will also say, because I do legal malpractice work, if you think you're going to get sanctioned or there is an issue that is sanctionable that is on the table, inform your carrier, get help. Don't immediately either get on the defensive or immediately fall on your sword. Get advice.
Michael, in the same lane as social media, but also other websites, what about negative reviews online of lawyers? This came up at a conference I was at just a couple months ago, and it was a really big deal. I didn't realize for a lot of lawyers at small firms and at even big firms with not just clients, but opposing parties posting information on Google or Facebook or Yelp or anything. What are lawyers supposed to do when this comes up?
Sure. So the big thing to realize, and I'll talk about two different concepts. The first one is my absolute favorite lesson for lawyers on this is something called the Streisand effect. And if you haven't heard of the Streisand effect, it actually is named after Barbara Streisand. And the facts are so easy to remember that I'll tell them. There was a environmental group that was doing a survey of the coasts of California. And they got a letter or communication from some representative of Barbara Streisand saying, you need to take down these particular photos because they show aerial photos of Barbara Streisand's estate along the coast. And you can imagine what happened when people found out about this, of course, was they went to look at Barbara Streisand's estate along the coast to see what it looked like. And so the term Streisand effect is now used where someone objects to something, and because that objection goes on the internet, it goes viral and becomes a much bigger deal. So the thing that would have been relatively minor, if you knew to look for Barbara Streisand's house, you might find it. Well, Barbara Streisand has just drawn attention to it. And that is certainly a big lesson for lawyers. Often, we lawyers are very good at being clever with our words and taking very strong positions. And you probably have seen, lawyers responding negatively to job postings or posting bad job postings or, responding to negative social media and everything else. You really want to think, am I just drawing attention to this problem by saying anything? And then the second big thing to realize is that you really need to be concerned about maintaining your confidentiality of clients. I think it was Steve mentioned earlier about, everything you write should be with a smile. The big thing to realize here is that so often lawyers will get very frustrated with clients or with others who post things, and they will go ahead and disclose confidential information. The duties of confidentiality in most jurisdictions really prevent you from saying anything about client matters without client permission. including things, for example, that are included in publicly filed pleadings or that may have been mentioned in depositions or the like. So people often think, well, the other side knows this already, so I can say it. The answer is not necessarily. You need to be really careful. And there are lawyers who get in trouble for it. There was a case called Gonzalez out in California where the lawyer had done a number of things, but one of the things that the lawyer had done was that she had disclosed information. A client had written a negative review, and the lawyer decided to attack the client's parenting style and parenting abilities. This did not go well for the lawyer. And that's the type of thing that we so often see. There are exceptions to the duty of confidentiality related to responding. There's an ABA ethics opinion. There are ethics opinions from other jurisdictions that say that does not include responding online. So what they generally advise is if you feel the need to say something, say, I don't believe this post is accurate, but my ethical obligations prevent me from disclosing further facts about it, and just leave it at that. I really tell my clients who are lawyers, most of my clients are lawyers, the less you can say, the better. And often, go ahead and write that really pithy response and then email it to me. Don't put it up on the web. I'll get a good chuckle out of it, and you'll feel better. You'll get the cathartic response, and then we can move on to things. It actually, believe it or not, is a good way to do it, or, read it to your spouse or whatever. But don't put it up on the internet, because more often than not, the client or the opposing party may have put up lies and the lawyer gets in trouble for it. So it's just not worth going down that road.
Not by coincidence, but I give the same advice that Michael had just described, and rarely do my lawyer clients provide me with their anticipated post as a sounding board. They decide, gee, this really is good. I've read it 3 times, and it's pithy and witty, and I'm going to look like the smartest lawyer in the room. And they reveal things that they just don't recognize as being confidential. And the confidentiality rule doesn't just apply to a narrow world of communication, but rather everything the lawyer learns while representing the client. And without the consent, the post by the client or the client's spouse or some friend of the client isn't an invitation or a waiver of that confidentiality obligation. And Michael mentioned the ethics opinions that were issued. It's remarkable that lawyers are faced with not only reviews by their clients or former clients, but also reviews by adverse parties, adverse counsel, and then there were anonymous posts. There's an ethics opinion right on that really gives precise guidance. It was issued back 2022 by the State Bar, I believe in Michigan, which gives remarkably pithy but concise and not specific, case-specific suggestions about each one of those types of reviews by your client, former client, adverse party who's self-represented or otherwise, adverse lawyer, or the anonymous. And that suggestion back even in 2022 is remarkably restrained and makes everyone else who sees the lawyer's response recognize that the lawyer does have restraint, is an ethically compliant lawyer, and not someone who's willing to reveal the improper parenting skills of their client simply because they're seem to be invited by the client or former client posting that information online.
Michael, moving on from the technology topic into just some of the more basic ethics principles, one of the areas and rules that you identified as coming up often in ethics opinions and cases that we see is conflicts of interest. What are we seeing lately in that realm that sort of become a bigger deal these days?
Sure. So one area where we've seen things, and it's interesting because it steps into a little bit of a substantive issue as well, relates to bankruptcy cases. There have been some very large cases that made the news. The one that frankly really made the news was the franchise group decision that prohibited Willkie Farr from continuing its representation of a company that includes, for example, Pet Supplies Plus as one of their brands. The reason for that was because of the work that had been done prior to the filing of the bankruptcy. These bankruptcy cases are often immense. I mean, they're fees that run into the millions. Often they pay at very high rates. But the ethics rules come into play, and also there's a particular provision in the Bankruptcy Code, Section 327, that prohibits counsel from representing a debtor if that counsel may have adverse interests. And in that franchise group decision, it looked back at some of the prior work that had been done and said, based upon prior work that had been done for the company and also prior work that had been done for one of the large former owners, who I think at that point was just a creditor, they were not going to allow things to continue. And this is something where we see firms, bankruptcy law is often sort of a leader of some areas because it is an area where the courts are so involved and invested in things. But it's certainly an area where firms really need to recognize the need to be careful. And I will say that there are a lot of areas, even in other topics as well, where firms often think, oh, it's okay for me to do this work. Firms don't like to pass off their clients. They've been doing work for someone and there may be some sort of change. It's really critical to realize that the conflict check is an ongoing thing. And if you have new parties added to the case or new owners added to the case, or if your client does declare bankruptcy or something, you really need to step back and say, okay, there's been some sort of change. Is that change material to my conflicts? And if so, do I need to go ahead and get out of the case, or do I need to go ahead and get conflict waivers to continue in the case? And a failure to make those decisions properly can result in disqualification, as it did with Willkie Farr, or it can result in disciplinary action as well. So it's really important that lawyers are always thinking about the status of being conflict-free, or at least unresolved conflict-free, is an ongoing status that can change as other circumstances change.
The one risk that you didn't mention, which comes as sometimes as a natural consequence of having a conflict encountered during pending litigation, is the disgorgement of fee earned during the conflict that was not uncovered until some other point. And disgorgement of fees that you earn for work that you performed isn't covered by insurance. The professional liability insurance will cover a lot of things, but not disgorgement of fees. And again, besides the reputational aspect of it, a fee that you've earned and been paid, you'll have to give back. And that really is a significant risk that can't be overlooked, particularly with the importance and the ease with which conflicts can be uncovered in most instances.
Yes, and an additional consequence I didn't mention, and this is, by the way, my only real legal ethics joke. What do you call a legal malpractice case where there's a conflict waiver? I'm sorry, where there's a conflict of interest, and the answer is a case that you settle. And then the second part of the joke is, what do you call a malpractice case where there's a conflict of interest and a conflict waiver? And the answer is a case you settle for less. And the reason for that is if you have a malpractice case and you're saying something went wrong, we've suffered some injury, then the good plaintiff's attorney is going to say, is there a grounds for liability? And part of that liability is always going to be, well, you had a conflict. And if you say, well, but I had a waiver, they always say, yeah, but you didn't mention this in the waiver. You didn't, beat the client on the head with the waiver. The waiver's never going to be enough. Right. So it really is a good reminder that, if you've got a conflict and you've also got a bad result, that you really are setting yourself up for a lot of potential problems, including, as Steve mentioned, disgorgement of fees.
Well, and it becomes an interesting issue, and it's not just these giant bankruptcy cases with, multinational organizations. It can be representing, mom and pop owning a business down the street, but then they want somebody else in your firm to do estate planning, but then the kids are taking over the business. And how does that all work together? And if you have sort of what we refer to as business waiver kind of things, not a true conflict, but sort of a conflict, how does that play in? And how does it play in if things really start to go south? And I think, yes, your joke is well taken.
Keeping our mind on fees for just a minute or two, Julie, let's talk about one of the latest ABA opinions that came out just last month on client communications. And this one had to deal with not communications with your current client, but what duties do you have to continue communications with your former clients? And I bring fees up because your relationship with the client has ended, but you're getting requested to continue on providing information. Can you send me this document? What can we talk about what happened here? How long do you have the duty to continue these communications once it's ended? I mean, what's the ABA's new opinion say?
I will say this is near and dear to my heart because I switched firms less than a year ago and I had a lot of non-billable time. And basically, what the thought is you understand your files, you understand your thinking and strategy on your files. It generally, even the most well-documented file doesn't put all of your brain into your file. And so what the ABA has said is that there is an obligation on your part to, if new counsel calls you up and says, hey, I don't get why you did this. What was the thought? You need to tell them. Now, obviously, not all of them are a situation where, oh, a conflict has developed, or it may be a lot more hostile. And a lot of attorneys, back when everybody had paper files, they're like, I'm not giving this over. They need to pay me and they need to do this. This is almost an extension of it. Obviously, you need to give your file if they want to transfer counsel, but an idea that you have some obligation to not materially harm your client's case. You need to talk to them about it. Now, there is an exception in here, and essentially, it's a gap filling obligation. You don't have to produce, like some giant written document. The expectation is somebody calls you up and you answer their question. But one thing is, if it is hostile, the ABA makes it clear that you can inquire why they want to know. So if you know your client left because they were ticked off about how some transaction went or how some motion went, you can ask the new counsel, is this in preparation for a potential malpractice case? And if the answer is yes, you do not have an obligation because the ABA sees that as outside the scope of the initial representation. It's kind of a thin line, however, I will say that. But yeah.
Steve, let's we're almost out of time here, and we've actually got just one more new ABA opinion that came out. So I guess we're kind of right on time here. This one also had to do with former clients, and it had to do with when you withdraw from representation, how much can you reveal to the court or to the public or opposing counsel about that withdrawal? What's the ABA's new take on that?
Actually, it's not new. It is the latest version of the approach. And in 12 pages, the December 2025 opinion describes the lawyers and reemphasizes the lawyer's obligation to keep quiet. They suggest some language. The terms they use are professional considerations, prompts the lawyer to make these decisions concerning a withdrawal. And it involves, obviously, the withdrawal of representation in litigation, where you're representing and serving as an advocate for a client. They suggest highlighting the balance that's created by what's sometimes called in our world, when we represent lawyers, a noisy withdrawal, something that the lawyer feels needs to be described, needs to be revealed in order to satisfy the obligation and explain why they're leaving or terminating their relationship with the client. The more noise the lawyer makes in that departure, the more challenging and more risks he or she is creating for themselves, because the rule governing confidentiality, Rule 1.6, is counterbalanced to and does restrain those reasons that we can utilize to terminate a relationship with a client under Rule 1.16. And that the opinion describes a sequence, and they describe use of bare bones motion. It uses terms like ethical dilemma or professional considerations. It says the sequence of greater revelations is only in response to the court's A, invitation, or B, an order issued by the court. But again, those are narrow exceptions to the confidentiality rule.
Yeah, I know most of my the jurisdictions I practice in, lawyers are required to file a motion to withdraw. So most lawyers are faced with, they think, well, I have to say something, and maybe without realizing, well, actually, I'm not supposed to say anything other than request withdrawal. And then if the court wants you to come to a hearing or say something further, I guess you got to address it then. But I think we've all seen many a motion withdraw that maybe cross the line a little bit.
And it's easy to cross the line when you have so many reasons to either you've been terminated or you're terminating the relationship that you have with an existing client.
It becomes
Absolutely.
more complicated when judges will not let lawyers out. And I've certainly seen that as well.
This opinion highlights the need for judges to read it to understand the vernacular. Professional considerations should trigger some, on the part of the judge, should trigger some recognition of a problem. Same is true with the suggestions that I use, which are ethical. The lawyer is presented with an ethical dilemma. These should be recognized methods of illustrating to the court, yes, there's something more, but I can't reveal that at this stage.
Well, many thanks to our great panelists. We are right at the end of the hour. We also want to thank again our co-producer, the National Law Review. Again, this is Financial Poise. And if you have any questions for our panelists that you're just now thinking of, or you think about later, or you're watching this on demand later, remember you can send those questions to by email to info@financialpoise.com. Thank you again for joining us, whether you're live or you watch this in the future. Thank you, everybody.
Thank you, everyone.
Bye-bye.